Okay, people, let's try that again. Let's try that one more time. Àwọn ayé lọ́yọ̀ọ́, àwọn ayé. Ṣé mo? Let's try that one more time. You gotta be kidding me. This thing is doing the same thing. Okay, so we had let's see, if it doesn't work, then I'm just gonna do live another time. We had a very, very bad storm yesterday in our area. Like when I say storm, well, not even storm. There was a tornado that went past our area, so a lot of lines are down, and so I think that's what's going on. The connection is coming in and out. Xfinity is what we have here. So, and then awaye. For those who don't know what aye is, listen, y'all the make. Yes, it was in the news. It was that bad because I had, like, on the way to work today, there were like massive trees falling on I-20. It was that bad, but we thank God for sparing. I mean, a few people passed in the storm, but thank God for sparing. Those all the lives that He spared. A lot of damage. Okay, people. So, thank you. Let's get right back into this. I'm back. Knocking wood. 𝒊𝒎𝒎𝒊𝒈𝒂𝒏𝒕 again. This is Attorney Abisola Olale Samuel, immigration lawyer based in Alabama, representing immigration clients in all 50 states. If you've got an immigration case, my firm handles that case tap. We can and do represent immigration clients regardless of the state you live in. What are we talking? Is always asking how do I arrange my hair. I don't arrange the hair. It's braided. I'm gonna do hey Mr. Roland, I'm gonna do a video one day of my hair and what I do and how I braid it. Nobody touches my head. Listen, I deal with migraines a lot, and so there's some days that I just cannot look at screen. I can't look at anything with light, so I have to turn everything off. And those days, like if you email, I'm pretty good, I want to say, in responding to emails. You would always get a response. I always tell people, give me 48 hours. But if more than 48 hours has passed and you don't get a response from me, I'm most likely having a migraine bout. So I say that to say my head, and I don't know if my mom is here. Since I was a kid, for the longest time, my parents couldn't figure out what was wrong with me because I was always just like, don't touch my head. Literally, I looked like my older brother growing up. So we both had low cut. The only difference is I had little studs, one stud back then. Now I have 4 holes, but so nobody touches my hair. Nobody touches my head. No, I can't do it. But anyway, let's get right into it. We're going to talk this evening about filing an I-751 before the 2-year period. So can you file if you're on Instagram, if you're on YouTube or Facebook? You can see what's on the screen. If you are on Instagram, we're talking about filing an I-751 before the 2-year period. Is that possible? That's what we're going to talk about. If you need to contact us, the number is 334-341-4475. Even your husband, don't touch it. I'm not married. I was married, but I'm not married right now. I'm not married. Let's just leave that alone. But anyway, filing an I-751 before 2 years. Is that possible? And if it's possible, who is able to file an I-751 before the 2-year period? So what is an I-751? An I-751 is what you file. It's a petition for you to go from a 2-year green card to a 10-year green card. That's as simple as it is. That's basically what it is in a nutshell. If you are, and who gets a 2-year green card? You get a 2-year green card if at the time you get your green card, your marriage is less than 2 years. There's an employment-based petition as well. One of the employment-based that you get a conditional residence. But as far as marriage, if your marriage to your green card holder spouse or citizen spouse is less than 2 years at the time you get your green card, you will be given a conditional residency card. That is the 2-year green card. And it's only good for 2 years, as the name implies. For you to get a 10-year green card, you have to file a petition to USCIS and apply for that. That petition is the I-751 form. So that's what you file. Generally, you are required to file that form together with your spouse, joint petition. However, there are situations because listen, a whole lot, hey, Miss Salome, how are you? A whole lot happens in 2 years, right? A whole lot happens in 2 years. Like people get married and get engaged, get married, get divorced, have a baby, all of that in less than 2 years. That is possible. So, because life happens and because immigration also understands that because you had a rosy marriage for like 2 years doesn't mean it's going to stay the same. Listen, people get married, people meet, get engaged, get married, and all marriages in less than 6 months. It's America. So it happens. So if you cannot file with your spouse, then you will be required to file a waiver-based I-751 to get your green card. So let's back up. I-751 you file only when you're going from a 2-year green card to get your 10-year green card. If you're required to file jointly with your spouse. If you do not file jointly with if you're not going to file jointly with your spouse, you must have a waiver ground for which you are requesting. So the waiver is basically you requesting USCIS to waive that requirement of filing jointly with your spouse. Those grounds are that you had a good faith marriage, but it ended in divorce. You had a good faith marriage, but you have been subjected to abuse by the spouse, or that you will suffer extreme hardship if you do not get your 10-year green card. Those are the main grounds when it comes to marriage. The other grounds, like if it's a child that is involved, or if your spouse passes away. Now, we're talking about if your spouse is still living. If your spouse passes away, it's still part of your ability and eligibility to file before the 2-year period. So if you're filing jointly, you have to wait 2 years, and you're able to file 90 days before the 2nd year anniversary. But can you file before the 2 years? Yes. On what grounds can you file before the 2 years? If you are filing on a waiver ground, meaning you are filing without your spouse, and you're filing a self-petition I-751 based on good faith marriage ended in divorce, good faith marriage abused by the spouse, good faith marriage the spouse has passed, or no good faith required, extreme hardship is the toughest ground to prove. So if you have good faith divorce, good faith abuse, good faith death, it's easier to prove that than the extreme hardship. If you're filing the waiver-based 751, you're today, and they're like, you gotta be kidding me. I was like, I'm not kidding you. And it turns out a lot of people do not know. I've had a lot of consultations that people were like, I've been suffering for my spouse, or we've been divorced for a year. I want to know, how that's going to affect me when I file in 2 years. And I go, you don't have to wait the 2 years. Like you could have filed as soon as you got divorced. Yeah. So if you are not filing your I-751 to get your 10-year green card with your spouse, you are not required to wait the 2-year period. You're able to file as soon as you get your conditional residency card and you meet those requirements of any of the waiver grounds. If you get divorced in 6 months after you get your conditional residency card, you can go ahead and file for your 10-year green card. If you're subjected to abuse because from the end of the spouse, you can go ahead and file your 10-year green card based on abuse. On the abuse ground, there's additional information on that. If you are filing a 751 based on being subjected to abuse at the hands of your spouse, and that spouse is a citizen, if you are granted the 751, your 10-year green card based on abusive, extreme cruelty abuse from your spouse, which is very, very similar to a 𝒊𝒎𝒎𝒊𝒈𝒓 case, you are still able to actually apply for citizenship when you get to that 3-year mark as a green card holder. So for the most part, before your 751 is adjudicated, you'll probably be at the 3-year year mark and will become eligible for citizenship whether or not you're still married to that citizen spouse. Did you get that? I'll say that again. If you file your I-751, which you're able to file before the 2-year period, given the length of time that's taking USCIS to process anything, and you're granted your 10-year green card based on abuse, good faith, but abuse, you've been subjected to extreme cruelty, and your spouse is a citizen, you made the 3-year legal permanent residency period, you're able to file for your citizenship at that 3-year mark rather than the 5-year mark, whether or not you're still married to that spouse. Is that cool? That's freeing. It's like an hallelujah moment. But anyway, so that's that. If you are in a situation where you have a conditional residency card, you are going through crazy stuff in the marriage, and you're wondering, okay, I got to still put up with this for the next 2 years, you're incorrect. Talk to an immigration attorney, find out what your options are so you're not stuck in a marriage that God doesn't intend you to be stuck in. Let's just put it that way. Okay. Yeah. Let's see. CR1, it's not all CR1, but CR1 will depend on, if you got your green card, it's because there's CR6 as well. If you got your conditional residency at the embassy, meaning you got an immigrant visa, or you did your adjust your status in the United States. Okay, so let's see. Questions, people. I would see. Let's see. Tell me, we're waiting to ask questions. People are already putting their questions. Go ahead and put your question in the comment section. Hey, Miss Pam. Yeah, I don't know. The reception just went off, but we're back. That's okay. Let's see. Y'all don't have a lot of questions tonight. That's good. Is it because it's late? Thursdays usually, because my baby, well, I still call him baby. He's my baby. TJ, the 11-year-old, he plays soccer. Well, what we call football. He plays soccer. So he's got soccer practice Thursday evening. So that is priority. Got to go get the kid from soccer practice. Okay. It should take both for me. I love that. Mr. Lavanja 𝐸𝐴𝐺𝐸. Okay, Justina 𝐸𝐴𝐺𝐸. But let me put it. Y'all, if I tell you how much clearly I can see, Allah would you know well, because okay. Cecilia, hello from Los Angeles. Thank you for all the information and the confidence you share. Thank you. Okay. Hash, my favorite lawyer. Yeah, you want to psych me, first of all. And then we say that in Nigeria, psych. If you receive the VAWA prima facie determination and have removal proceeding in court, what is the best option to take or the best advice you suggest? Disclaimer. If you need anything specific to your case, you got to set up a proper consultation, proper paid consultation. So this is your general information. Someone in your position, hash will, if you have a lawyer, ask them to seek prosecutorial discretion. I always reach out to the trial attorney, the ICE attorney, before I file anything with the court. It's a lot easier if you're doing it jointly as a joint motion than to, and then, you get some good ones and some you just, whatever. And if I reach out to an ICE attorney and they oppose my motion, I would just put it in the motion that I already tried to reach out and see if we can have a motion. But, DHS opposes this motion. So I'll put it in the heading, unopposed or opposed motion by DHS, whatever the case may be. But that may be the best thing to do. I'm waiting on, when I was waiting on, we got the okay to go ahead and file a joint motion with the court, which I filed this week. So that is awesome. Hopefully, knock on wood, we get it. My goal is to have it terminated, but I would take administrative closure. That's fine. So there are a couple there I'm still waiting. So that was really what I would suggest to do. Okay. And Valenzuela. I applied for VAL and I don't qualify for residence card, but my daughter is derived and she's available for the green card. When she can apply for that? Okay, Anna, are you asking, or if what are you saying is you applied for VAL? You said you don't qualify for residence card. So you say you don't qualify for the green card. Well, how do you know you don't qualify for the green card? Because right now, is it based on abusive spouse? If that's your classification, if your spouse was a citizen, then that's an immediate relative. If the spouse is a permanent resident green card holder, it's current right now. So how would your daughter derive if and she has the green card available and you don't? I don't understand your question or how you've asked it. So if you want to rephrase your question or tell me what status your spouse is, it based on marriage? And what is your spouse, green card holder or citizen? Either way, there's visa available for green card holders. So okay. Let's see. My interview has been over 2 weeks now. I'm laughing because 2 weeks. Okay. There's no update to my application online. Still says interview was scheduled, but my employment authorization was approved. Please, what could be wrong? There's nothing that could be wrong. 2 weeks. I reserve my comment, but nothing could be wrong. Cookie Baby 143. Do you have to all have to travel with AP? Cookies Baby 143. Can you rephrase your question? That's not making sense to me. Okay. Chioma Ajaga, I've gone for interview for 2 weeks with no update. Is that you, Chioma? No, that's different. 2 weeks is not, listen, people. 2 weeks is not anything. 2 weeks is not, it's 2 weeks. Now, the question you should ask yourself is, okay, how was the interview? Were there discrepancies? Did they ask me, okay, have you been married before? Did you file a petition before? Is there something wrong with your divorce decree? If everything checks out, then just be patient. It's just 2 weeks. We're talking of USCIs. They don't do anything in a rush. Now, have I had some cases where we have an interview and next, a couple hours later, we get notification it's been approved? Yes. But do I have cases we've been waiting a year? Yes. And we've been writing and asking and like, what's going on? But I did a video about, especially if it's marriage based, I did a video one time ago that the time you're waiting is not just for you to wait. That is time been given that they can just show up in your house to see whether or not what you said during the interview checks out. If it doesn't check out, they're pretty fast to send you a denial notice. So, but 2 weeks is not anything. I am Rosani. What advice do you give to someone who has their marriage-based interview coming up? That is advice that I give to clients. So if you don't have an attorney, I would suggest scheduling one and prepping as much as you can. So the basic advice I would have is prep as much as you can with your spouse. Know everything about that spouse. Know everything in the house you claim to live in together. What is the color of the front door? What is the color of your microwave? I've had an interview where they asked my clients what the font color of the microwave is, not the color of the microwave itself, the font color. And then it told them, like, how would you even know? But it's not about knowing what the one is, and they were separated. They want to see if you're paying attention and what the other spouse would say. So if you get there and your spouse says microwave is stainless steel, and you get there and they say it's black, not a lot of people pay attention to color of the microwave. But if you're anything like me, I don't miss anything. Like, I'm nosy as hell. I wouldn't say I'm nosy because I don't even know the names of my neighbors. So I'm very, very private, but I I'm nosy about things that I need to know. For instance, what goes on in my home, I need to know. What goes on outside of my home, I don't need to know. Except if it doesn't have anything to do with me, I don't need to know. But color of your microwave, you should know. Where did you guys go over the last weekend? What is your spouse's favorite color? What is the name of your mother-in-law? Where does your mother-in-law live? What is the color of the car you drive? What did you guys do yesterday? What did you have for breakfast today? You can't forget what you had for breakfast. If you get there and say we stopped at the high up and your spouse says we didn't have breakfast, you can't make that make sense. Because if you stop for high up, that means you stopped together. You cannot forget that you stopped. So just know one another. Um, Stone Zell, must you file your tax return with your spouse as a 2-year green card? There's no must. Taxes are evidence that you're commingling finances, but if there's a reason why you don't, for instance, y'all, most of you are Nigerians. Most of us are Nigerians, right? We have, as Nigerians, and I can talk from my parents, we don't usually grow up in a system where parents have joint account, right? Like each parent has their own account. So if you're able to say it's not I'm just not used to that. We've used that as as a reasonable explanation, and that worked. But if you had taxes initially together to your green card, then you have to have a reasonable explanation why you not stop filing tax, so it doesn't look like the only reason you did it was just to have bona fides to start with. So it's not a must. It's advisable, but it's not a must. Okay. Let me make sure I'm not missing anyone's question. I may not be able to get. Okay, I gotta go. Do you have? No, I told you to rephrase that if you don't mind. Do you have to travel with advanced parole? No, you don't have to travel. If you want to travel, yes, that's why I file it, because I have clients who say, "Oh, I'm not going anywhere into my case," and then you see that it's taking forever. Like, okay, I need to go somewhere, and we file it later on. But you don't have to travel. You don't have to use it. I just always file it for everyone, unless a client tells me I don't need it, I don't want it, and then if they change the amount later on, then we do it. Can someone travel out of the country when your change of status is still pending? If you have an advanced parole that has been approved and it's still valid, then yes. If you don't have an advanced parole, if you travel, then your case will be deemed to have been abandoned. Enough said. Antonio, they went through my I-485 and I got some questions wrong, some worried, so I feel they're inconsistent answers. So when you separated from your spouse, Yums 14, does denial based on abandonment of petition by petitioner qualify one for VA coupled with other things? So I was just about to say that the coupled with other things is what you need to be able to discuss with an attorney and see if you're eligible. So coupled with the other things, I would need to know. So based on just abandonment, there's no requirement that your spouse has to file a petition so you can get your green card. If someone says I'm not doing it, that's their choice. If someone says I'm not doing it because they want to use it to manipulate and control you, then that's different. That is abuse. That is controlling behavior to keep you where you are. But if someone says I just don't feel like doing it, if you're not okay with it, you can divorce and go your way. That's not by itself abuse. Coupled with other things, then you have to discuss those other things. Okay, people. No, I cannot do a request for video right now. Why is USCIS separating the work and travel document? This is because they say it is going to be faster. So what, and I had a seminar seminar, like the virtual seminar, where the explanation is this: because for the most part, they're saving resources and combining, it's a combo card for your EAD and advanced parole. sometimes the advanced parole will be approved, but then the EAD has not been approved, or vice versa. So now they're trying to do the way one is not dependent on the other. So if they're going to approve your EAD, they'll send that to you. If they're going to approve your AP first, they'll send that to you. Whichever, they'll send it to you rather than wait for both to be approved at the same time and then send those to you. So that's why they're doing that, which I think is a great thing. So that, and the reason behind it is if they're trying to work on employment authorizations faster, get those out and not have that be delayed because they're still waiting on your advanced parole. Ken, does changing lawyer affect or delay a VAWA case, please? It should not. Cookies, baby, you're welcome. No, I was not separated, but she was not asked any questions at all. So if she was not asked any questions, what discrepancies are you talking about then? Or inconsistencies are you talking about? What was inconsistency if she was not asked? What happened if after interview case under review it's been 6 months? That's just generic. It just depends. Every case is subjective. It just depends on how your interview went and why it's under review. At this, you're just waiting to see if, for the most part, what I have seen, and I keep telling my clients, if things change, you've got to let me know, because they do these days just pay unannounced visits at any time. They're doing it more frequently now than ever before. So under review doesn't mean, okay, you go your way, I go my way, then we come back with no. What else can you show? I gotta go. As proof, if lease is not available, a side affidavits from a few people, you but live together with a friend rent-free, and that friend is not willing to do an affidavit. What about people, neighbors, photographs, joint account, because lease is not the only thing that you have. Joint credit card. And joint account, when I tell you guys joint account, is not just, oh, I have your name on the account, so but I'm the only one using it. That's a red flag. If you have an account that both parties are not having access to, that's really not credible evidence. So, oh, okay. They ask you questions about your I-485. Okay, so inconsistencies. If it's just about your information, then information on an I-485 are not necessarily inconsistencies, because something being inconsistent is you're comparing it to somebody else's information or contradictory information. I-485 from time to time would have typographical errors or people just don't understand what the question is. I can't even tell you how many times we've been at the interview where right there we have to correct some information because the client gave me information. It was like, oh, that wasn't what I meant. Like, oh, okay, you should have told me that before we came here. But the officer will correct it and it hasn't been a big deal. Now, if you falsify something, say for instance, you say, were you ever denied a visa? And you say no, and they see that your DSI 60, they have it, and you were denied visa like 4 times. They'll ask, why did you say no? I'm like, oh, okay, I forgot. That's, yeah. Or if you say, have you ever been married? And you say no, and they pull out your information and say, well, you said you were married when you got a visa. And you also, attach a marriage certificate. Yeah, okay, yeah, that's going to be a problem. But anyway, all right, people. So gotta go. Okay. Real quick, Hash has a good question. What is the difference between VAWA cancellation and cancellation removal proceeding? Cancellation removal, you have to acquire a 10-year period. VAWA cancellation removal is 3 years. It's the same thing like a regular VAWA case, but you're just in removal proceedings, and you have to show extreme hardship. Cancellation removal, you have to show that if you're not granted your removal is not canceled in the way you can apply for your green card, is going to cause hardship to your spouse, qualifying relatives. VAWA cancellation removal, you can be the one that hardship would, so that you can show that if you're removed, it's going to be extreme hardship to you. So 3 years, 10 years, you being the one who's suffer hardship. The other person is you have to show qualifying relatives. Okay. Anna Valenzuela, my lawyer said I don't qualify for green because I have too many entrants to US. Okay. My daughter only have one okay, so now you're talking. Okay. My question is once we have then she can apply for your kind of case is one you would have to sit down. Listen, if you're looking for a second opinion, then you would have to sit down with an immigration attorney and give your exact facts. Obviously, there's a whole lot more to your case, and that's why I knew that was a whole lot more from your first question. This is something that's not a yes or no. This is something that has to be give me what the facts are. If you want to do a consultation with us, it's $130 for 30 minutes and $230 for an hour. If not, find someone else. You can sit down and get a second opinion, but it's not a yes or no question without knowing all your facts. All right, people. Question about an I-130. What can you do when your case is still pending? You file for renewal since 2 months. It's just 2 months. If it's within our pressing time, then it's not a long time. Okay, everybody. Once again, go follow us on Instagram, TikTok, subscribe to YouTube. What else? Like a page on Facebook. Until next time, everybody. If I don't see you guys tomorrow, may or may not stop by. If not, I will see you guys next week. And nobody should be playing no April Fool's Day joke with me tomorrow. Just saying. I may play with you, but just saying. Just leave it alone.